So I'm the public administrator in Shelby County, the probate court. The public administrator is a public office. It's created by statute in Tennessee. There are a number of counties that have a public administrator. For a long time, Shelby County did not. And the probate judges in maybe about 15 years ago decided it would be a good idea to start that here in Shelby County. And I served in that role ever since then. The public administrator is a person who the probate court can be assigned by the judges to serve as a fiduciary in a case. Most often it's decedent's estates, but sometimes guardianships, sometimes conservatorships as well. And the judges tend to appoint me, and I think that it works a little bit differently from county to county, but in Shelby County they tend to appoint me where they identify a need for a third-party neutral fiduciary to serve, and oftentimes not just neutral, but a person who's a lawyer that has experience with probate and help with that case in whatever way. The types of cases that I tend to get involved with are ones that really two ways. One is from the outset, and that's where either the lawyers in the case recognize that for whatever reason they need to have a third party. Sometimes that's because one lawyer's faction of the family won't be happy with the other lawyer's faction, somebody from that side serving as executor or administrator. And the lawyer B's faction family won't be happy with anyone from faction A. So a lot of my cases, maybe half, come from lawyers who call me and say that we have an estate, we really think we need somebody who's neutral to serve as the administrator, and again, sometimes guardian or conservator, and can you help us out with that? So that's probably about half of it. And the other half comes directly from the judges who, on their own initiative, identify the need for the third party. And again, sometimes it's because the family members don't get along. The family acrimony is a big driver. Another situation is where I get appointed after the fact. And in those cases, it's because usually the estate has not been administered correctly. Sometimes parties file a petition to remove the existing administrator. Sometimes it's because the administrator has filed an accounting that has some problems or red flags, and the judge thinks that they cannot or should not continue. A lot of the cases, and it seems like not quite as many now as in the past, but a lot of the cases involve some sort of fiduciary misconduct where the administrator has stolen money from the estate, or some form of stealing money or misspending assets. And in those cases, I'll file claims typically against the administrator's bond, and often the administrator makes the action as well. Does that cover everything?
I think so. John, you want to start us off with kind of the top of the outline since you've done this before?
Sure. Scott, I have a question for you related to that, and then I'll get into initial client interview. So you mentioned litigation. When you do litigation, are you often working with another attorney? Are you being the administrator and attorney for the case? Depending on the circumstances? Or?
It depends on the circumstances. And a fair amount of cases where I serve as a public administrator involves some sort of litigation. And usually I'm the plaintiff and the lawyer. In some cases, I will get somebody else from my firm to assist, just depending on the scope of litigation. But usually I handle it myself. Most of the time it's a relatively straightforward cases.
Let's say if I bring a case to you and say, hey, I think the judge, and I probably wanted you to serve as public administrator in this estate, but there's going to be litigation. will I be able to represent you and be involved? Do you work on that basis as well, or is it usually too many people, too many heads in there, and the cooks in the kitchen?
Usually, yeah, it's too many. I think that it will depend on the circumstances. Typically, though, I think the judges expect me as the administrator to just take the ball and run with it.
Sure.
And frequently, there's some sort of conflict of interest, and a lot of times, in particular in the case, the person that was attorney director really can't stay involved anymore because they represent the previous producer who's first.
Well, I won't call you if you're not going to. I'm just kidding. So, guys, we'll, if you guys have questions, obviously, about anything in particular, just raise your hand. We'll try to get them as we go along here. But let's talk a little bit about the initial client interview, when to have it, who do you want to be there. I generally, it's a cop-out. It's a case-by-case basis on when I'm having the interview, who I want there, who I'll let be there. And it depends on the circumstances for me. Jason, do you have any preference on when the interview, as far as a probate client? I mean, are you meeting with people pre-death about mom's estate, or you say, hey, call me in, they call it the dead funeral, call me in a week?
My preference is get that morning period over with before we start talking business. So I just generally say, take care of your affairs. Have a funeral, call me a week later when you're thinking clearly. Keep track of your bills.
I've had initial interviews with multiple family members in there, more than just the executive or personal representative. I've had other beneficiaries there. I like that under most circumstances because I use that as an opportunity to manage expectations. Any guys have any experience when you don't want other people in there, or maybe it's your preference to have as many people as possible so you can say, all right, guys, this is how it's going to work. You're not getting your money till then. This is what the expectations on attorney's fees, on time frames, on distributions are going to be. You guys have any scenarios where that changes your opinion?
I generally only meet with the personal representative, or who will initially or ultimately be the personal representative, just so there's not any confusion as to the attorney-client relationship. So it's clear that we will be representing that personal rep in their capacity as a fiduciary to the estate, and so that there's no, just to kind of avoid that confusion that we work for this individual. So that's generally our practice.
I will tell the other people that, hey, I'm their attorney, not everybody's attorney. I'm happy to answer questions. But we had a question here in the front.
I was going to give my opinion. I usually just meet with the personal rep, but my firm had a couple of black farmers litigation cases, and the person who's coming to us were the ones who've been still paying on the property. They've been doing everything, so they think they're supposed to get everything, and then I have to enlighten them and say, well, you don't have a will, so it don't just go to you, it goes to your 10 brothers too. And I need you to make sure you tell me who all these people are and give me an address. So in that instance, I don't know if I want to meet with all 10, but it might be a good idea because the person who came to me first has some warped idea on how this is supposed to work. So no, I need to let more than just you know how this works. I need to probably have a conversation with all y'all in the same room. But I usually just meet with the person with her.
Sure. Yeah. Okay. Great. I think it's a great example where you've got a lot of different players involved, and you got to figure out, okay, I guess here's how it's going to work.
Yeah.
Your expectation is not what's reality. So I think that's a great point. Scott or Jason, you guys want to talk about the client interview? What's that initial client interview look like? Do you send out a questionnaire beforehand on those? Does that on a case-by-case basis? Do you do that? What do you do in those? Is it when they come to your office or want to come to your office?
I tried questionnaires before, and I find that the few times I've done them, I always end up changing a lot of what they've put down. They don't remember, or they don't realize it's significance of something. So I haven't done it in a long time.
Sure.
That's been my experience as well. Questionnaires are maybe for just basic information, but normally you're going to have to drag it out of them and they're going to question the answer process personally, one-on-one. So I have not found for state matters that questionnaires that helpful.
I like them for certain things, specifically when I've got a lot of family members who don't have a will. Or even when we do have a will, I want to know where everybody lives, where their address is, how to spell their name, that type of thing. So I don't have to go through in our meeting when I'm billing by the hour and say, all right, is that, how do you spell it, an A or an E or what's, what's that? It can be helpful, but it can also be frustrating. I got your questionnaire, do I really need to fill this out? So I try to fill it out on a case-by-case basis. Josh, what about family dynamics when you meet with people? What are you trying to dive into? Do you want to know who hates who, where the skeletons are buried, or you let that come out now?
I think that's something you generally get a flavor for in just speaking and just having a conversation with folks. I think that's, it kind of relates to the questionnaire. I do not use a questionnaire, and I think that I don't for some of that reason, so that it requires kind of some increased and detailed dialogue, and that conversation then sort of leads to, you kind of will get to the relationships of folks. I will, if I sense that though, I do a lot of times ask, how is the relationship? Is everyone, there are times that I will ask that, and sometimes even explain that on the front end that, look, this process can go, there's a lot of leeway that the law will give you if you can operate by consent. Conversely, if one person, if there is kind of one person who objects, that can really throw a wrench into the timeliness of this, the cost of this. So that is something that, I won't say I discuss every time, but that is something that I do bring up, sometimes in a very direct way.
Any thoughts, you guys, on discussing fee structure or billing with people outside your client beforehand, so that everybody knows what to expect? You don't get to, and generally, my experience is at the end of the state administration is when everybody else sees my bill probably for the first time. They may have called me and I may have told them, bill by the hour, here's my hourly rate is, every time I'm working on your case, I bill in 6-minute intervals. There'll be a bill with detailed billing at the end. Do you have conversations with beneficiaries and other people about how that works, or do you usually leave that up to your client?
I do have that conversation with residuary beneficiaries when it makes sense to have it, because if they acknowledge the fee agreement, then you'll have less issues later on. I hate surprises, and clients hate surprises. So if you can kind of establish your fee beforehand, I think you'll have less controversy later.
You said acknowledged fee agreement. Do you share your fee agreement with the residuary beneficiaries?
When I can, I share my fee agreement with residuary beneficiaries. So there's no question as to what my fee is. It's usually an hourly basis anyway. So.
Okay.
John?
Yeah, absolutely.
And I understand what I'm talking about, it's an hourly rate at the beginning, but clients always ask, well, just give me a ballpark, just how much, and until you really get started, you have no idea if they're creditors, if we're going to test the will. How do you handle the ballpark question? Because then if I'm evasive, then at the end they're like, I had no idea it'd be so much, or this is a lot cheaper than I thought. It's hard to mitigate those expectations at the beginning, in the very first meeting, when you don't even know what you're dealing with.
I don't have an answer for that. I habitually underestimate how much it costs. Unfortunately, yeah. So I don't have a good answer. I know, the local rules have some guidelines set out in there. I don't particularly use those. I know that other attorneys do. Like, okay, here's what kind of, I've used them. I take it back. I've used them before. Here's, if we go to court, they aren't. It's not good law anymore. But here's what the judge would expect. A ballpark figure to be is what's in there for the local rules. But sometimes you get a case where it's a relatively small state, but you're going to well exceed those guidelines that are in there, and because of the issues involved. I don't know, you guys have any, Laura as well, jump in, if you guys have any thoughts on the best way to manage those expectations regarding fees. What do you tell people? How do you put them at ease to some extent?
Everybody wants to know that, and I don't blame them, I would too. And it's so hard to try to guess. And I've sometimes I'll give people an estimate, and I'll say, well, you know, the majority of the cases I handle are between here and here. Some are less expensive, some are more expensive, sometimes way more expensive. And I will tell people a lot of times in front end that there are 4 drivers of cost in probate. One is family acrimony, one is unusual assets, like proprietorship, litigation, and what's that? Creditors, possibly. Yeah. So, and I think all you can do is just try to explain as best you can what drives the costs, and I think a lot of times people understand that it really is hard to predict. I'm like you, I tend to underestimate sometimes. When wishful thinking, you get it in under a certain figure, and you know, it's always just a longer stuff.
I was funny, my dad was probably 50 years practice here, and he used to always go high. If you go low, you mess up everything. You go high, and you're a hero if you just come in on. And it's a lot easier while the honeymoon, to get it out.
That's a good point. My conversations with my potential client, usually there's some potential client when I have a conversation. I don't scare them off. Don't want to shoot too high. But that's great. I mean, you want to keep them happy. You want them to return when they need something else. So if you can stay under your estimate, like Wiz said, that's obviously ideal. For keeping your clients happy. Hopefully, it will be repeat business or referral source in the future. So.
Okay, because I'm looking at the clock and we haven't made any progress. So, what are you guys looking for when you're in the initial client interview, or the client has retained you and you're looking at the will? Who wants to jump in? Jason, you start.
Sure. All the information, all the beneficiaries, legal names, addresses, contact information, as much information as you can get on that first interview, so you can complete your petition and go to court. That's what I'm looking for. And even looking for, you might get social security numbers for, you certainly, if you're anticipating a 1041 coming down the road, you go ahead and start getting that information as well.
I would add the how assets are titled. That's always just going through the title of any accounts, so you can go ahead and kind of narrow down what should be the probate estate.
Do you go ahead and tell clients to bring you all the documentation, like the initial client meetings? I know I've had clients who really, that scares them off.
Yeah.
When you start that process.
I typically don't, but not at the initial. I will tell them if they have any, to the extent they have documents available, please bring those. If they're not available, that's okay, we can discuss. But I do want to try to get an idea of what accounts are out there, list those out, and then follow up at that meeting, say, okay, these are kind of develop your master checklist at that meeting, and then follow up with, okay, the next email is how was this account titled? How was this we use that as sort of master checklist?
Okay. And then next on the outline, I'm looking at asset information, determining type of probate. Do you guys have much experience handling this distribution directly from a bank, or not handling many of those?
I've never done that. I know some of the other attorneys in my office have had success actually doing it. I think it's going up or going up recently. It's going up. It was at 15, it's going to 20, or it's going to 15?
I think it went from 10 to 15. I actually checked that just today. There are 2 statutes, one for banks, one for
Can you explain that?
If you don't need to open an estate, then you can still get a bank account closed and get a check to there's a statute 45-3-5 or 4, is it listed? There's one statute that applies to banks, one that applies to credit unions. And it says that you have to wait 30 days after the death, and at that time, if no estate's open, then you maybe do a death certificate, But they'll close the account and issue a check to, there are maybe 3 people listed, one is next to Ken and others. And I did it with Orion today, so email to them. It helps because Orion's local and they have a general counsel. So I did it through there and we replied, and so once we get the best certificate, we'll get a check, assuming that you don't have to.
So you went directly to general counsel for them, or did you?
That was the only person I knew.
Sure.
Other than,
I mean, I think that's the best way to do it, if you can get in touch with them.
right, and the main thing we were concerned about in this particular case was, we asked them to freeze the account, because apparently there were a lot of auto pays and things, and rather let those people file claims. That's really good.
You said the amount for the distribution from the bank has to be
Oh.
under 15,000.
It has, I think the total of all the accounts, as I understand it, has to be under 15. It used to be 10, so I think they were just.
Yeah, well, I think it's part of the omnibus bill last July, I want to say, it was a part of that they raised the cap on that from 10 to.
John, do you want to kick us off starting about drafting your petition to open an estate?
Sure. So the information you need for that is going to come from the will and from your first meeting. We've got a lot of the stuff listed in there. If a lot of times, if it's a current client, like I called somebody today, mom had just passed away last week. Mom was under conservatorship, so we need to open up a probate estate. I'm not having a meeting with them. I've got most of the info I need, but I said, hey, you got to fax me or scan a copy of the will to me, because I need that info. I need to attach that to the petition. So I'm not actually going to have an initial meeting with them, but they're an ongoing client, so they know what to expect as far as everything else. But your initial meeing is going to be important for that. Obviously, you can call and get other info for that, but that's going to be important. We should have most of the stuff listed as far as what you need in that petition to open, whether it's testate or intestate. There's a statute that dictates what's in your petition contents. I think that's really the bare minimum of what you need in there. That's 31,117. And then you'll be taking the order with you to court. To some extent, if you know what to expect, you usually can have your nice order without having to interlineate or go back and change it. But it's not all that uncommon for Judge Webster and Judge Gomes. I think I both last, so I can speak a little more freely. To change orders. Judge Gomes, I felt like it was a point that she loved my first couple of years of practice, writing on the orders. And so I would take multiple different orders of, I think Judge Gomes is going to do this. This is my option 1B if she says, I'm going to do this, and I try to surprise her with that. But she really likes writing on the orders. Less than so frequent now, but it happens often.
What do you guys do to prepare your clients before you head into court? Who wants to start? Jason, you want to start?
Sure, I try to walk through, I'm usually driving my clients down, best case scenario, I'm usually driving my clients down to court. And so I kind of walk them through the process because they don't like surprises. So I just kind of set their expectations, tell them where they're going to sit, what questions will be asked, expectations as far as the court's concerned, so that they have some confidence when they walk in there. That it's very, it's upsetting to them. Family members has just passed away, and this is kind of a scary process.
So you guys all have your client ride with you in court? Scott?
I don't.
Okay. I usually don't either. I've made exceptions, but I've got 3 little kids, so I've got more than one person riding in my front seat. I've got to vacuum the goldfish, which takes extra work after I change diapers and get bottles and all that. But if it's my client, it depends on the circumstances. I'm not saying I won't. But it's a good practice, I think. You get to prep them a little bit for what to expect when you get down there. Usually I'll say, hey, meet me down there at 8:45 at the latest, and we'll talk in the hallway about some of those things like Jason and Josh probably prepping for.
I
I have a kind of a touchy subject, and I want to hear how other attorneys deal with it. They don't ride with me, you know, meet me down there, but do you discuss how to dress, like particularly in the summer? I had one bad instance where a client showed up and like a free pants. I didn't find them offensive, but the judge did. And I had thought to say, you know, you can't show your ankles, and, you know, things of that nature. And I think it might have offended my client if I attempted to tell her how to dress her for it. So I didn't know if there's something online we can send them, or it seems like I saw something, but a lot of mine are not.
I haven't totally had a problem with needing to tell them, but in free pants, I could see that
In the summer.
surprising, yes.
That's in my letter, I put dress and business attire, and I give them a map. When I go through what's gonna happen when we go to court, I just tell them what to wear. Be sure you don't wear any sleeveless shirts, you don't wear any short skirts. I just go through the whole spiel and tell everybody the same thing, and they just, no one seems to have a problem.
I do it, Christie does. I mean, I say to them, I'm gonna be in a suit and you're dressed like you're gonna be business attire like from a church.
Can I ask a question out of order from the outline? What do you do when you have a case and you get a whiff that somebody is like draining the assets or abusing the power of attorney, or I just need one solution, just go ahead and I'll write it down.
So is your question?
One step I do.
Do they come to you, for representation and you say, or is it
Well, you know,
somebody else in the family's been doing it?
Right,
or somebody else?
I mean, I deal with a lot of elder abuse where there's a family member abusing the power of attorney or something, or, you know, but in any situation, just give me that solution.
If it's your client, you're limited on what you can do, right?
If it's my client, I'm gonna go ahead and punt, and they're no longer my client.
But if it's somebody else, maybe, like another family member.
TRO, so I mean, sometimes a letter, if I think there is truly some immediate irreparable harm, then the TRO can be appropriate, but I would have to really, we would have to have a real conversation, or they would have to be able to provide me some real details of this is what's going on before I think I jumped ahead of a letter or, you know, straight to some type of TRO with a preliminary injunction. But that would be kind of and there's a new law out now, you know, they've got that new, where it's, I believe it's criminal now, haven't they made that a criminal under the, where that type of abuse actually carries criminal punishment on it, as part of last July's law. So that would be something that, you know, Arkansas has done that for a while, and I think Tennessee last year kind of mirrored some of the Arkansas statutes, so that's kind of some new teeth that we have now. So.
I don't know if there's a good answer.
What I suspect.
But temporary restraining order, if it's ongoing, is usually the first thing. If the person has died and you've got a death certificate and you know where the bank is, usually you can get the account frozen without having to do a TRO. But you don't know if they've got assets in their hands that they took out beforehand, and you've got to cover all your bases and kind of go.
Yeah, you can freeze the account under that new, I mean, that's another thing we've got now where you can contact the bank and have the account frozen immediately. So maybe that's an intermediate step prior to the TRO. That's something that you've got in the box now. So.
Person's competent, maybe they'd be willing to go through the power of attorney. If they're not, I think there are a lot of cases where that ends up calls for partnership action to be filed, that would be the only alternative. Then after the fact, you know, if you want to try to remedy that, I know the power of attorney statute has a provision that require the agent and the founder to provide an accounting. There's also
Have you ever seen that done though successfully? Has anybody seen it? You have, okay. These people come to court and account.
Well, I've had several actions like that, and I've always alleged that. And I don't know that the agent has ever actually counted. Usually, once I file the action, my sense of it is I get the bank records and I figure out what happened, and then use that as part of my case. That's there for what it's worth.
Josh, you want to give us a quick sort of summary of administering the estate? Just a quick little 30 seconds.
I try to take care of the personal reps affidavit. I try to take care of a lot of things basically right after I get back from court, just so that they're done. Gosh, it's a lot. I mean, that's my goal is when we get back from court, we're executing affidavits. Typically, we'll get the 10-care notice in right away. To the point where we're sort of just waiting on creditors' claims run, getting those, receiving the publication of those creditors from the clerk's office. We're trying to get us just into that 4-month window, and then during that 4-month window, I really try to move quickly through. I don't like to let estates linger. So to the extent I can, I mean, once we get through sort of the initial court, and 60 affidavits filed, notice 10-care, then I like to move just right into, set up with here you need to get an estate account set up, get assets kind of marshaled if they need to be, deal with assets as they need to be dealt with, any titling issues, and then move right into, if there's any 1040s, have a discussion about taxes, whether we're going to be handling that or you got a CPA handling that. But get, if there's any real property, one thing that that I think not a lot of attorneys pay attention to is if there is a mortgage on any real property, yes, title passes, but only 99% in almost all deeds of trust or notes, the death of the maker is an event of default in those deeds of trust, and so you need to have a conversation pretty early on about how you plan to address any real property. If you're going to keep it, if the beneficiaries are going to keep it, I let them know, look, you need to keep paying the mortgage, but at some point in the near future, you need to move to getting this thing refinanced because I almost guarantee that you're technically in default. Never seen a bank declare an event of default if the mortgage was being paid, but at the same time, you don't want to have it. I mean, that would be a terrible situation if your client's paying the mortgage and all of a sudden they get a note from the bank saying they're technically in default. So I had a conversation about that, about sort of beginning that process. But basically, I like to try to move to where I think we're in a good position shortly after the creditors close. I mean, that's really my goal in every administration is to use that time period to just knock stuff out. So that's.
You mentioned the state account. Do you do that the day you open it, or do you usually wait?
I will instruct them the day that I open it, kind of on that car ride back a lot of times. Here's what we're going to do at the office. Here's what we've got on the agenda once we get back to the office. And that's, you can go right now, take your letters down, open up that estate account.
I believe it may have been in the practical suggestions from Venom and Southern. They're almost as old as me. Did say that they want the attorney to go with the client to open the estate bank account. It may actually, everybody familiar, there's a packet they give your personal reps when you open an estate account, and I always tell them this is your nighttime reading, but don't worry, I got all this covered. It may say it in there as well, because I had a client call me one time and said, hey, when are we going to set up the estate account? I was like, well, I gave you the EIN number, just go to so-and-so where the other account was that your mom had and open it up. She's like, no, this is a difficult client. No, I need you to go with me. I'm like, all right, I'll go with me, but one, she already was complaining about hourly rate. I was like, I got to charge you for it. So I think that's in there. A lot of times, if we've got everything we need, I'll go with them afterwards to the bank and make sure the estate account gets open. I usually get on the phone with my assistant and get her the docket number, the title of the personal rep, and get that EIN number first to open the account.
Can I ask something? Do you guys
Absolutely.
do that? Do y'all go with your clients to the bank to open the estate account? Okay.
I did at one time when the judges were emphasizing that, and I think the judge there in particular was pretty strong about that. So I had a case where I hadn't done it. But I don't sense that the judges today feel strongly about that at all. So I haven't done it a lot. But I do try to give the clients pretty good instructions about always needs to be IN, and we get it for them 100% of the time. And I proceed social, like your social, put it in the name of the estate. So long as
Yeah, that's good.
Do y'all will you serve with your client, maybe an out-of-town client, as co-personal representatives so the bond will get waived, or joint control, anything like that? I guess you'd be administrator, CTA, co-personal. Do y'all do that? What's your roles?
I was in front of them
Yeah.
a while ago, and I said, I'm serving with another attorney, who's in Alexandria, Virginia. He said, we have the bonding attorney bond. And he did. So, I don't know what the current judges do.
I prefer not to. I think the bond is the best way, the best practice. But I mean, on occasion, I will serve as a co-fiduciary, but there would have to be a situation where I know exactly what has happened with the families. It would have to be a very close, at least business relationship.
I've waived it all.
I would generally, it would have to be someone almost family or where they're very, very close business relationship. I think people to act, to do that, and then, yeah, I don't know the family. And I'd probably have to be the marriage referral as well. Have to explain it.
Gotcha. 'Cause it involves joint and several liability
Yeah.
for the state assets, and I think that there are just too many things that can happen. I just not comfortable with that. I've done it before, and but I got away from that.
You want to say a question?
Yeah, I just want to pick it off, right? I'm dealing with the case where my client was appointed as the substitute or successor administrator. The original administrator had not, his attorney got escaped or whatever, so nothing had been filed, nothing was done right. And so since then, my client's got an administrator, but the judge still required the form administrator by the county, because we don't know, we don't have nothing to show, what's in his estate, what's it distributed to creditors, or, we don't have nothing. Well, now we're at the point where he won't respond, and the judge issued a show cause order. This is like the third one, and she said this is the last one she's gonna send. Have y'all had situations like that? Like if he won't comply, does that mean cop or a sheriff is gonna pick him up? I mean, to get documents, what does that mean?
I haven't had that scenario, but I've had scenarios where I've had to get an order from the approach board to have the Shelby County Sheriff go pick somebody up. And it was actually taken to a doctor's appointment and then taken to Lakeside. But if you'll get with me afterwards, I can just send you the form. It was in Webster's Court. It was a conservatorship. But I think you can probably, go talk to the judge and be like, here's what I want to do. What kind of notice do you want? They've already disobeyed the show cause orders 3 times, so I think you can hold them in contempt and issue a writ for the person essentially.
Patrice, you're saying the original administrator has documents, things related to this thing, you cannot.
Well, he came to one hearing, which is the one where my client got appointed, so he was upset about
Yeah.
it. So he came and he got on the bench and said, yeah, we got in the state account with $10,000 in, yada, yada. So the judge said, okay, well, you got all the documents and accounts open, send them to her, file an accounting, and you can be released from your duties. He hadn't done it.
Yeah.
So,
Yeah, I would, one thing I'd use is just subpoenas in that situation, where you subpoena documents, subpoena bank records from someone, and that gives you then a little bit of ground to stand on if you needed to move for some type of contempt, as opposed to waiting on the court to act. So it's one thing that could be one way sometimes folks will respond to that, so. that's the situation.
Who wants to tackle dealing with claims by creditors? Jason, you go.
Basically get that list up front, find out who all the creditors are, notify creditors' claims are filed, file your exceptions timely. Make sure you get them in timely. If there's, I have clients who, we assess, we don't know, you never know how many claims are going to be filed, and there is the claim statute is there for a reason. So I normally do force all the creditors to file their claims. If it's a situation where there's not very many claims, and you know that for a fact, and there's small claims, we might settle those because it would take far less, that's less expensive for the executor to handle that than an attorney. But for the most part, I don't know what your practice is, I make the creditors file their claims and then we handle them through the claim statute.
Yeah, for me, it's a case-by-case basis. How much money we're dealing with, what's the relationship among the family members with our executor? Is someone going to complain when we pay a $50 AT&T bill that we know has been cut off and it's for the last month while the person was alive? It's case-by-case for me as far as whether I'm small claims, I make them file a claim, or some commercial rep, and you go ahead and pay it without the big issues there.
Yeah, I agree with the case by case as well. Some folks will just pay, other times when you file.
There's that statute that allows a personal rep to pay claims if it's under 1,000, somewhere, without a claim being filed, or I guess pay a debt without a claim being filed, if it's under 1,000. And so if you have an estate that you know is solvent, and you have some little bitty bills, and the family wants to go ahead and do those, it's not.
Scott, will you walk us through, it's time to close the estate, so what do you do step-by-step process?
I guess I have sort of a mental checklist. You want to be sure that the final tax return has been filed with the city, that if there's a 1041 that has to be filed, that's been done. You've got to have your 10-care release, you've got to have, depending on the date of death, possibly something about inheritance tax. I guess assuming we distributed the estate already, so you have to have received waivers from everybody, or if it's not a situation that's really practical, then you've got to file an accounting. And what else I think about? I have a sort of form distribution spreadsheet that I use on most estates, and it has a list of claims, and or just it says claims, there's a place for the filling claims, there's a place for the filling court costs, bond agreements, and I use that just as a checklist to remind me to verify that I'm taking care of all those things before we distribute the estate.
So let me ask you guys a question. Do you send out the money first, or do you send out the receipt waiver first?
Receipt waiver. Sign this, and I'll send you a check.
It doesn't work the other way.
I would say I probably sent the check first when there's some limited circumstances, but and again, that's on that's when I take my case-by-case basis, and the pool of cases where I've done that shrinks drastically. But generally my practice is, okay, here's what came in, here's what's gone out, here's what the total is now, here's how we're proposing distribution, sign the receipt waiver in front of the notary, send your original back to me filing, we'll get you a check or whatever shortly thereafter.
Another thing that's important to send out at the same time, I think, if you haven't already done it, is a W-9 to each beneficiary so you can get their social. I've had that happen several times where send the checks out and somebody will never send back their social, file a 1041, and it's going to involve K1's issue. So that causes problems. So, that's another piece of paper that is good to get at the same time or before you send the checks out.
How do you guys, somebody comes in to see you, a client, and they have, what you determine would be a small estate. John, why don't you tell us how you handle that? What's your involvement as the attorney?
I try to fill that out and see, if they've already come to the office, they're probably wanting to hire me to do it anyway. If they call me and say, hey, Mom's got $10,000, everything else is joint, how much is it gonna cost for you to do this for me? I have to pay this, and this, I'm gonna say, no, form's online, go get it and go. But if they come to the office and, you know, they're needing help on other stuff, I'll generally do the small stuff for them, and walk them through that process. So, you know, sometimes I'll just say, hey, it's not my time or your time for you to hire me to do this. I can't charge a low enough fee on this for, you know, you to be happy, for me to make money. So I'll just say, you know, do yourself, if you have questions, call me. Well, probably don't call me actually, because I don't want to be your attorney. You know, giving you legal advice when you're not my client. So, but, you know, I'll do a good amount of those, help people with, because a lot of times, you know, you can do those with me with a title. You can do those when you've got a revocable living trust, and then you've got some assets that you put in there, or, you know, people are aware that that was outside. So I will do a decent amount of those. You gotta wait 45 days, you gotta have to see its death certificate to do those. I wasn't here for the judge's talk, but I think most of the time you're gonna have to have a bond when it's between 25 and 50. Just some preference of the court, but don't plan into that. You know, hear what the judges would say about it if they're interested. Okay. I know a lot of times they didn't have questions. So I know a lot of times you go to court, I think that probate judges, when it's between 25 and 50, which you can still do a small state affidavit, they'll still require a bond, even if you've got all of the heirs at law, but residual beneficiaries signing the waiver, just because there's too much abuse that goes on for those. So just prepare your client with, hey, you're going to have to pay a bond premium. You know, the bond premium is not going to be that much, but you're going to have to pay a bond premium between 25 and 50 for your small states.
And then who wants to tackle you this time? Josh, you want to get?
Yeah, so for those that may not be familiar with the union of title is an effective way of transferring title. The only asset is the property, and that's all you're dealing with. You can file a union of title. You don't have any personal representative. It's not really a state administration at all. It's go down to court. File your agreement, and that the will is admitted for purposes of the unit of title. So a lot of times you will need to do this if you've got a sale. If a client wants to say, look, I want to sell this property, a lot of times you'll need to do that for the purchaser to obtain title insurance. They may need title insurance cases as well. That's kind of the remedy for that. And that's pretty straightforward.
One note, Shelby County, union of title, you and your client, if you've got a will, you and your client have to show up. I've said the will. You and your client have to show up. Fayette County, I think you and your client have to show up, but I think you can meet the clerk and master there. I don't know about all the other counties. I know in Obion County and Gibson County, you can do that via mail. By mailing them the original will, you petition the order, you don't have to make a copies. So usually when I have something outside Shelby County, I can call the clerk and say, hey, how's it going? And you know, we'll try to be nice and don't necessarily tell them from Memphis. But I've got you the title. Can I handle that via mail, or do I have to actually come and see you guys? I'd love to come see you guys, but you know, my client don't want to pay me to do that. So sometimes you can get away without a personal appearance. You make a trip to wherever around Memphis. But in Memphis, you and your client generally have to show up for those unit times.
When you go to do it in Fayette County and you meet with the clerk and master, is that a specially set hearing, or is that you just show up at a certain time to go to court?
I usually schedule it with clerk and master. I believe it's still with those. But he's usually pretty available. It's not, I don't think it's like our walking hour from 9 to 10, but he usually does.
Okay. Jason, why don't you break down affidavits of heirship for us?
So the affidavits of heirship, intestate estates, you need some So there's no will, you need to have some clear path of title, so you file 2 affidavits. Well, now the title companies are saying just 1 affidavit of heirship. It's a statement from a third party as to who the heirs are at law. It's signed under oath. And I know that the title companies are saying 1. I still generally get 2 of those just as a redundancy, just for whatever reason if they found fault with 1. But it's just a way to pass title to the property without having to go through the probate court because there's no will and there's no probate administration.
Yes, so just so it's clear, these 2 things clear up the chain of title. I mean, that's what the purpose of these, of the unit and the active
And on the muniment, the only other thing I have is in my order, sometimes I specify in the order as to who the actual fee owners will be after the muniment. I know the court's not really analyzing that, but I usually put it in the order just because the title company, you don't want to leave it up to them to interpret a will. So I might just give them a little bit of a, head start or some direction as to who the fee owners are of the property, even in the muniment title.
Question?
Oh, this might go to yours, so when you get the order for the muniment and the title, do I have to do like a quick claim deed from the, or is that it just the order?
That's it, it's just the order, but the orders will be recorded when there's a conveyance, so you can, although the probate record is part of the public record, I think as a general rule, the title companies are saying that that order still needs to be recorded in the clerk's, in the registrar's office.
Okay, it don't have to be a quick claim deed following that order.
No, it's the document that conveys, the will serves as that conveying document, sort of that gap document between the decedent and the heirs, so when the heirs go, when the heirs go to sell or do whatever they need to do, ensure they can show.
And that's where I was going with the order. So when someone's searching title and they see that order, there might be something, an extra line there that says the fee owners of this property are John and James.
So, okay. And do those have to be especially said in Shelby County, or just open court?
Units?
Muniment and title.
Muniment title.
You can walk us through that.
Walking.
Yeah, that's open court.
And you, how y'all charge for that? Hourly or? Okay.
I'm usually pretty good about giving a flat fee on this, because I know what it's going to take on those. So I'll do a flat fee on this sometimes.
Okay.
But if they start having other issues, I'll immediately tell them, hey, I'm happy to help you with this, it certainly relates, but my fee quote is solely to do community. And I generally, when I leave court, I believe it's the clerk's secretary will get you certified copies. I'll take a certified copy of the order and the will and have it recorded so that they don't have to, because usually if I don't do that, the title company will call me later and say, hey, can you get this, or do you have a copy already? So I'll just go ahead and do that.
And with the muniment, go ahead and get your 10-K release as well, because that will be required in closing. So even though it's not necessarily required for the muniment, I don't believe it's required for the muniment, I will go ahead and get that release because it will be necessary for the closing.
This is required in Gibson County. They wouldn't let me do my order until I got my 10-K release.
Two questions. I'm kind of from the real estate side, or heavily from the real estate side, so I would say that 90% of the affidavits we look at are wrong and don't muster with the title we want. I think the key thing to remember when you go to if you do the affidavit of they have to be from a disinterested party, and you have to set out details. Why, X, Y. You have to list all the possible areas, and if you don't do that, you can find out they let somebody else get close on something, you'll find them never coming back. And so it's really important to have a very, very thorough affidavit of issue, especially if you only do one. And 2 is always preferable. But the other thing is, we run into the question of there's a will. The only thing you really need to do out of the will is the real property, but it's so much cheaper to do the affidavit of heirships. But the will said, and in the affidavit it says, was there a will? No. Right? But if there is a will, then it says yes. And so how do you all feel about that situation where there is a will?
I've seen affidavits of heirship where they change the language to make it sound, to say that they don't reference the will, but they say that there is no probate administration required. And I've seen that pass the title company. I do not do that. My statement's going to be that there was no will in the affidavit of heirship. If there is a will, you need to go through the minimum process. That being said, I have seen affidavits filed that say there was no probate administration required. I do not think that meets the statute.
I don't think it meets the statute either, because I've had people come to me and say, why do we have to do this? And when they weren't pleased with my answer, I believe the small state statute, or excuse me, the affidavit of heirship statute says one of the requirements is no will. I think, don't quote me on that, I don't know in front of me. But, and then I've seen where they've gone and done a small state after they left off, or affidavit of heirship after they left the office. I didn't do it, so I just watched my hands.
On the affidavits of heirship, you just really want to think through it as an attorney, you know, what was important here. Was there a divorce? Were they married? Who were the children? Were there any children, any deceased children? And then it gets very complicated because when you have multiple, you know, if this has been put off and you're trying to determine heirship and there's multiple generations, you can really have problems there and need more than one affidavit of heirship.
The other thing that we run into a big problem with is you file the affidavit, you don't think about when people get ready to sell the property, right? You find out one of the heirs is in bankruptcy or one that huge tax liens and judgments against them. So as soon as you put that affidavit of record, you've now created an issue where they can't sell the property. So I think the other thing from the probate side is you've got to, if they come in and you advise them to go with the affidavits, I highly recommend you check out who the parties going to, you know, try to turn around and sell the property, because if we get them to run that thorough title search, and it shows up that, you know, okay, he's inherited not just the property, he's also in chapter 13, and we've got to get a court order. So sometimes I've seen people actually, what is it called, disclaim their interest in the property, and not actually, just because of the judgment or some issue that's been created, something where the family can't sell.
Good point.
Questions?
On the 60-day affidavit, I've seen two different processes where one, the personal rep will sign the affidavit, but I've seen another where the attorney will sign. Is there a pro or con either way?
I only do personal rep. I think it's the personal representative's requirement. I will sign it as their attorney when I file it on a different line, but I have to sign it.
Yeah, I'll always
Now, I'm the one sending the letter to the beneficiary, just giving them notice and all that, but I still make the personal letter. So. Any other questions, guys?
There's a similar statute, deposit box, 60 days.
Similar to the bank release of funds? Yeah.
Specified name or anything, it's just, so look at it and I'm going to transfer. I've used that.
Because that's all the time we've got. Thank you all very much.